Now, real estate, you want to title your homestead real estate into the trust name, but only if it is a qualifying trust under the Texas Tax Code and the Texas Property Code. Do not transfer your homestead into an out-of-state trust. You will lose the homestead exemption. Now, people have heard trusts are valid all over the US. That's true. Your California trust is valid in Texas. It just doesn't comply with our tax code and our property code. So if you put your homestead into your California trust, you've lost your homestead exemption, which is a significant loss. We're not really going to talk about all the benefits of that today. Upon sale, the trustee signs the deed to transfer to a purchaser. People ask, well, how do we sell it? The same way you would if you owned it individually. You put it up for sale as a trustee, and you sign the transfer documents as trustee. That's all there is to it. You may be required to record a certificate of trust to meet title standards if the trust owns real estate. This is not a difficult process, and it should pose no problem, but it isn't required in every single case. Some states require it, some states don't. It's possible that some counties are going to look for that. In Texas, real estate is transferred when the deed is signed. Texas is known as a deed state. Other states, it's not transferred until the deed is recorded. Those are known as race states because the deed isn't valid until somebody races to the courthouse and gets it recorded. Recording the deed is not required, but we highly recommend it. Recording puts others on notice regarding the correct owner. It also gets it recorded in a courthouse just in case your house burns with your only copy of your deeds. Yes, that's happened. Steps to align your real estate with your trust. Well, number one, have an attorney licensed in the state where the real estate is located prepare the deed. First of all, it's practicing law without a license to prepare a deed in a state you're not licensed in. But secondly, it's not even safe to copy an old deed. The state might have come along and changed the deed form, or it might not have been right to begin with. The deed should have an acknowledgement for the trustee to sign, showing the trustee accepted the asset into the trust name. That proves delivery to the trust. Now, some institutions will say, well, the trustee never signed this. The trustee never agreed to this. But if they've acknowledged it, that argument disappears. Sign the deed as the grantor, that's the transferor, and as the grantee, that's the transferee. Normally, the grantee does not have to sign. But again, doing so proves delivery. Record the deed in the county courthouse where the real estate is situated. The county clerk will put a stamp on it, on the deed, proving that it's been recorded with the county, and it also provides proof to the rest of the world of the trust owning the real estate. Now, be aware that deed records is where you do this, not the county tax office. The county tax office and deed records don't communicate real quickly with each other. So you can't say, oh, when Dad died, we took his name off in the tax records. That's all we did. But his name is still on it in the deed records. Now, when you're purchasing real estate, you can have the deed prepared by an attorney licensed in the state where the deed is located. Prepare the deed in the name of the trust. If you're going to get a mortgage on it, that's not likely to work. You'll have to transfer it later. The deed should have an acknowledgement for the trustee to sign showing that the trustee accepted it, and it proves delivery to the trust. Sign the deed as the grantee, that's the transferee. Record that deed in the county courthouse where the real estate is situated. The county clerk will stamp it so that you've got proof to the rest of the world that the trust owns it. Now, not all deeds are the same. General warranty deed in Texas warrants title back to March the 2nd, of 1836. In case you don't know your history, that's the day that Texas declared independence from Mexico. If you do a general warranty deed, you better have done a very thorough title search because you're responsible if it is inaccurate. A special warranty deed, which is what we normally try to use to transfer assets to entities, warrants title back to the date you obtained it. Now, you know what's happened on that property and with that property since you acquired it. But you don't know what happened 100 years ago. You don't know who might have claims that haven't been discovered. If we don't have enough evidence to do a special warranty deed, but we have good reason for believing that the person owns the property, we will do a deed without warranty. We were doing a deed for a ranch one time and it had this long meets and bounds description. And I called my old property professor for help. And we were talking about the kind of deed. And he said, in that description, is there anything that talks about an iron stake? And I said, yeah, there's several references to the iron stake at this and such, go this many feet, blah, blah, blah. And he said, have you been out there to verify that that stake is still there? And I told him, not yet. Well, we did a deed without warranty because we don't really know that that description is still accurate. At the time we were doing this, the last description was over 60 years old. The creek may have changed directions in that time. Somebody may have pulled up the iron stake. That old oak tree might not be there anymore. There's a lot of landmarks that just might not be there. So we put in the description we did a deed without warranty, so our client is not liable for it. Then there is something called a quitclaim. Quitclaims are not deeds. I don't care if it says quitclaim deed at the top, there is no such thing. A quitclaim will blow your title insurance. And it's appropriate only if you are not certain of the interest. So for example, I could sell, and by the way, call me if you're interested in this, I'm very interested in selling you my quitclaim to the Golden Gate Bridge. I can only sell it to one person, so there's only one, better, bid. And no, I'm kidding. So far as I know, I have no interest in the Golden Gate Bridge. But I could quitclaim my interest in case I do. That just says, I don't know if I have an interest, but if I do, I transfer it to you. There are some appropriate uses for quitclaims, but transferring assets into your home, into your trust, is not one of them. Transferring a quitclaim to your neighbor because you sold him a little parcel of land is not truly an appropriate way to do it, but it does transfer your interest in the property to that person.